I knew something was wrong the moment I saw Patricia Whitmore standing at my gate with that clipboard tucked under her arm like a weapon. The morning sun hadn't even burned off the dew on my ranch property outside Midland, Texas, and there she was, the HOA president of Sagebrush Estates, her blonde bob haircut perfectly styled despite the early hour. I'd been living on this land for 3 years, and in that time, Patricia had become the bane of my existence over issues ranging from my fence color to the height of my mesquite trees. "Kevin Kimball," she called out, her voice sharp enough to cut through the rumble of the drilling equipment being unloaded on my property. "We need to talk. Right now." I wiped the sweat from my forehead and walked over to the gate. Behind me, the crew from Lone Star Mineral Extraction was setting up their rig on the eastern portion of my 40 acres. I'd spent months negotiating the lease agreement, working with geologists, and consulting with attorneys to make sure everything was legal and above board. The oil and gas deposits beneath my land represented a potentially life-changing opportunity, and I wasn't about to let Patricia's notorious nitpicking derail it. "Morning, Patricia," I said, keeping my tone neutral. "What can I do for you?" She thrust a piece of paper through the gate bars. "This is a cease and desist order from the Sagebrush Estates Homeowners Association. You are in direct violation of Section 7, Paragraph 12 of our community covenants, which explicitly prohibits any industrial activity on residential properties." I took the paper and scanned it quickly. The legal jargon was dense, but the message was clear. The HOA was ordering me to stop all drilling operations immediately or face fines of $1,000 per day, along with potential legal action. "Patricia, this is mineral extraction on land I own. The mineral rights came with my property deed. This has nothing to do with the HOA." Her lips pressed into a thin line. "Everything within Sagebrush Estates falls under HOA jurisdiction. You signed the covenants when you purchased your property. You should have requested approval before bringing in this industrial operation." I felt my jaw clench. I don't need approval to exercise my mineral rights. That's not how property law works. "That's exactly how HOA covenants work, Kevin. You have until 5 o'clock this afternoon to remove that equipment, or the fines begin." She turned on her heel and marched back to her white Lexus, leaving me standing there with the worthless piece of paper in my hand. The crew foreman, a weathered man named Dutch Holloway, walked over as Patricia's car disappeared down the dirt road. "Problem? The HOA thinks they can block us from drilling," I said, crumpling the paper. "But they're wrong. My attorney made sure of that before we started." Dutch scratched his chin. "I've seen this before in other developments. HOAs get big ideas about their authority. Usually doesn't end well for them when mineral rights are involved, but it can slow things down with legal battles." "Let me make some calls," I said. "Keep setting up. We're not stopping." I walked back to my house, a modest ranch-style home with a wraparound porch that overlooked the rolling Texas landscape. Inside, I pulled out my phone and dialed Marcus Chen, the mineral rights attorney who'd helped me navigate the complexities of my lease agreement with Lone Star. Marcus answered on the second ring. "Kevin, how's the setup going?" "The HOA just served me with a cease and desist. They're claiming I violated community covenants by not getting approval for industrial activity." There was a pause, then Marcus laughed. Not a polite chuckle, but a genuine, from the belly laugh. "They said what?" "Kevin, send me a photo of that document right now." I snapped a picture and sent it through. While I waited, I could hear Marcus typing on his keyboard. "Okay, I'm looking at your property deed and the HOA covenants you signed," Marcus said. "Here's what they don't understand, and what I'm going to explain to them in very simple terms. Mineral rights in Texas are separate from surface rights. When you bought your property, you acquired both. The HOA covenants govern surface use, things like building codes, landscaping, noise ordinances. They have absolutely zero authority over subsurface mineral extraction. That's not how this works." "So I can ignore this?" "Legally, yes, but HOAs can be persistent and annoying. I'm going to draft a response that explains the legal principles involved. Meanwhile, I want you to document everything, every interaction with the HOA, every letter they send, every fine they try to levy. If this escalates, we'll need a clear record." Will it escalate? Marcus sighed. In my experience, HOAs that overreach like this either back down quickly when educated, or they double down out of pride. Your HOA president sounds like the doubling down type. He wasn't wrong. Patricia Whitmore had built her entire identity around being the Sagebrush Estates HOA president. She'd held the position for 7 years, running unopposed in every election because, frankly, no one else wanted the job. But Patricia loved it. She loved the authority, the clipboard, the ability to tell her neighbors what they could and couldn't do. Admitting she was wrong about something this significant would be like asking her to resign. Over the next 3 days, the drilling setup continued without incident. Dutch and his crew worked efficiently, and by Wednesday afternoon, they'd positioned the rig and were ready to begin exploratory drilling. The noise would be significant, I knew, but I'd already warned my nearest neighbors, the Hendersons, who lived about a quarter-mile away. They'd been supportive, even excited about the possibility of mineral deposits extending onto their property. Then, the fines started arriving. Patricia delivered them personally each day at exactly 5 o'clock in the evening. $1,000 for Wednesday, $1,000 for Thursday, $1,000 for Friday. Each notice was printed on official HOA letterhead and included increasingly threatening language about liens on my property and potential foreclosure. I forwarded everything to Marcus, who was building our case. On Friday evening, after Patricia had left her daily fine notice and departed with a satisfied smile, my phone rang. It was Marcus. "Good news and bad news," he said. "Good news. I've prepared a comprehensive legal response that definitively establishes your right to extract minerals. I've cited Texas property law, relevant case precedents, and the specific language in your deed. I'm sending it to the HOA board tonight via certified mail. And the bad news? I did some research on your HOA president, Patricia Whitmore. She was involved in a similar dispute 3 years ago in a development outside Austin. She lost that case badly, and the HOA ended up paying significant legal fees to the homeowner. But here's the thing. She tried the exact same overreach there. She either didn't learn from that experience, or she doesn't care. So she knows she's wrong and she's doing this anyway? It's possible. Or she genuinely believes her interpretation is correct despite legal precedent. Either way, this is likely going to get messier before it gets better. That night, I sat on my porch and watched the drilling rig's lights illuminate the eastern section of my property. The rhythmic sound of the equipment had become almost comforting, a reminder that I was finally making progress on a dream I'd held since purchasing this land. My parents had been ranchers their whole lives, scraping by on thin margins and the whims of weather and cattle prices. When I discovered the potential mineral wealth beneath my property, it felt like a chance to build real financial security. Maybe even leave something substantial for the future. I wasn't going to let Patricia Whitmore take that away. Saturday morning brought a new development. I was having coffee on the porch when a Sagebrush Estates security vehicle pulled up to my gate. 2 security guards I didn't recognize got out and approached. "Kevin Kimball?" the taller one called out. That's me. "We've been instructed by the HOA board to deny access to any commercial vehicles entering or leaving your property. That includes the drilling company's trucks and equipment." I walked down to the gate. "This is private property. You don't have authority to block access to my land." The guard shifted uncomfortably. "We're just following orders from the board, sir. We've been told to set up a checkpoint at the community entrance and prevent any industrial vehicles from entering Sagebrush Estates." I pulled out my phone and called Marcus again. While it rang, I said to the guards, "You're going to want to talk to your supervisor before you do something that could result in legal liability for you personally." Marcus answered and I explained the situation. I could hear the frustration in his voice. Put one of the guards on the phone. I handed my phone through the gate. The tall guard listened, his expression growing increasingly uncertain. After about 2 minutes, he handed the phone back. "My attorney has explained that blocking access to private property could constitute illegal interference with mineral rights, which is a serious civil and potentially criminal matter in Texas," I said. "You really want to be the ones named in that lawsuit?" The guards exchanged glances. The shorter one shook his head. "We're going to call this in." They walked back to their vehicle and spent several minutes on their radio. Finally, they drove away without another word. I called Marcus back. "This is escalating faster than I expected," he said. "The HOA is going beyond standard overreach into potentially actionable interference. I'm going to file for a temporary restraining order against the HOA to prevent them from blocking access to your property or interfering with your mineral rights operations." "How long will that take?" "I can have it filed by Monday morning. In the meantime, document everything. If they try to physically block access, call the sheriff immediately. Don't engage directly." The weekend passed tensely. I stayed on my property, watching the drilling operation progress while half expecting Patricia to show up with some new scheme. But Saturday and Sunday were quiet. Almost too quiet. Monday morning, Marcus called with an update. "I filed the restraining order petition with the district court in Midland County. We have a hearing scheduled for Thursday. I've also sent a formal demand letter to the HOA board requiring them to rescind all fines and cease any interference with your operations. The letter makes it very clear that their actions are legally baseless and could expose them to significant liability." "Do you think they'll back down?" "Honestly, I don't know. A rational board would cut their losses and withdraw. But the research I've done on Patricia Whitmore suggests she's not always rational when it comes to HOA authority. She sees herself as protecting the community even when she's clearly wrong." That afternoon, I got my answer. An email arrived from the Sagebrush Estates HOA board calling for an emergency meeting that evening to discuss ongoing violations by homeowner Kevin Kimball. The meeting was mandatory for all board members and open to any residents who wished to attend. I showed up at the community center at 7 o'clock. The parking lot was fuller than I'd ever seen it. Apparently, word had spread about the dispute, and curious neighbors wanted to see how it would play out. Inside, the main room was set up with chairs facing a long table where Patricia sat flanked by the other board members: Robert Jennings, the treasurer, Linda Martinez, the secretary, and Dale Hoffman, a board member who rarely spoke. Patricia called the meeting to order with 3 sharp raps of her gavel. "We're here tonight to address a serious violation of our community covenants by Kevin Kimball, who has refused to comply with HOA directives regarding illegal industrial activity on his property." I raised my hand. "I'd like to speak." "You'll have your turn," Patricia said dismissively. "First, I want to review the facts for everyone present. On Monday of last week, Mr. Kimball began drilling operations on his property without seeking HOA approval. Despite being notified of his violation and served with proper cease and desist orders, he has continued this activity. He has now accumulated $7,000 in fines, which will be placed as a lien on his property if not paid within 30 days. Robert Jennings cleared his throat. "Patricia, I've been reviewing the covenants and I'm not sure we have the authority to—" "We absolutely have authority," Patricia interrupted. Section 7. Paragraph 12 clearly states that industrial activity is prohibited on residential properties. I stood up. "May I address the board now?" Patricia looked annoyed, but nodded. "You have 5 minutes." I walked to the front of the room, holding a folder Marcus had prepared for me. "I appreciate everyone's time tonight. I want to be very clear about the legal situation here. I own both the surface rights and mineral rights to my property. In Texas, mineral rights are a separate estate from surface rights. The HOA covenants govern surface use, but they have no legal authority over mineral extraction. This isn't my opinion. This is established Texas property law, confirmed by dozens of court cases." I pulled out copies of the case citations Marcus had provided and handed them to Patricia. "My attorney has prepared detailed legal analysis showing that the HOA's cease and desist order is invalid. Moreover, attempts to interfere with my mineral rights through fines, liens, or access restrictions could expose the HOA to significant legal liability." Linda Martinez spoke up. "But the covenants do prohibit industrial activity. You signed those covenants when you bought your property." "The covenants can't override state property law," I explained. "Mineral rights in Texas are considered a separate property interest. Even if the covenants explicitly mention mineral extraction, which they don't, such a restriction would be legally unenforceable because it would constitute an illegal restraint on mineral rights." Dale Hoffman, who I'd never heard speak at a meeting before, leaned forward. Patricia, did we consult with an attorney before issuing these fines? Patricia's face flushed. We don't need an attorney to interpret our own covenants. The language is perfectly clear. Respectfully, it's not clear at all, Robert Jennings said, flipping through the documents I'd provided. These case citations seem pretty definitive. We could be exposing the HOA to serious liability if we continue down this path. We have a duty to protect property values and maintain community standards, Patricia insisted, her voice rising. If we allow industrial drilling on residential properties, what's next? Oil refineries, chemical plants? We have to draw a line. The line is already drawn by state law, I said. I understand the concern about property values, but mineral extraction is a temporary activity. Once the initial drilling is complete, the operation will be minimal, just periodic maintenance and collection. And the reality is that this could actually increase property values if other homeowners have similar mineral deposits. An older man in the back raised his hand. I recognized him as Frank Henderson, my neighbor. I've been doing some research since Kevin told me about this. Turns out my property might have mineral deposits too. If the HOA can block Kevin from drilling, that means they can block all of us from benefiting from our own mineral rights. That doesn't seem right. Murmurs of agreement rippled through the crowd. Patricia's expression hardened. This meeting is getting off track, she said, banging her gavel. We need to vote on whether to proceed with enforcing the fines and pursuing legal action against Mr. Kimball for covenant violations. I move that we table this vote until we consult with an attorney, Robert Jennings said quickly. I second that motion, Linda Martinez added. Patricia looked betrayed. You can't be serious. We have clear covenant violations. We have a duty to act. We also have a duty not to waste HOA funds on a lawsuit we're going to lose, Robert said. The prudent thing is to get legal advice before proceeding. The vote was 3-1 in favor of tabling the enforcement action and consulting an attorney, with only Patricia voting against. She adjourned the meeting abruptly, gathering her papers with jerky, angry movements. As residents filed out, several people approached me to ask questions about mineral rights and whether their properties might have similar potential. Frank Henderson clapped me on the shoulder. Good job standing up to her, Kevin. Patricia's needed someone to push back for a long time. But I knew this wasn't over. Patricia Whitmore didn't strike me as someone who accepted defeat gracefully. Over the next week, things seemed to quiet down. The HOA hired an attorney, a real estate lawyer named George Pritchard from Odessa. Marcus knew him by reputation and said he was competent and reasonable. That seemed like a good sign. The drilling operation continued smoothly. Dutch's crew hit their first significant oil deposit on Wednesday, about 800 feet down. The initial flow rates were promising, suggesting the lease could generate substantial revenue over the next several years. I started to let myself believe that maybe, finally, things were working out. Then, on Friday afternoon, I received a certified letter from George Pritchard. My stomach sank as I opened it, expecting more legal threats. Instead, I found a carefully worded letter acknowledging that the HOA's initial cease and desist order had been issued without proper legal review, and that after consultation with counsel, the HOA board recognized that mineral extraction fell outside the scope of HOA covenant enforcement. The letter concluded by stating that all fines were being rescinded and the HOA would not pursue further action regarding my drilling operations. I called Marcus immediately. Did you see the letter from the HOA's attorney? I did. He sent me a copy as well. This is exactly what should have happened from the beginning. George clearly explained the legal reality to the board, and they made the smart decision to back down. So it's over? It should be. Keep the letter for your records, but yes, you should be in the clear now. That weekend, I actually relaxed for the first time in weeks. The drilling operation was progressing well, the HOA had backed down, and the stress that had been coiling in my shoulders finally started to ease. Monday morning shattered that peace. I was working in my garage when I heard vehicles approaching. Looking out, I saw 2 Midland County Sheriff's deputies pulling up to my gate, followed by Patricia Whitmore's Lexus. My heart started pounding. I walked out to meet them. The senior deputy, whose nameplate read Ramirez, held a clipboard. Kevin Kimball. Yes, sir. We've received a complaint about illegal dumping on your property. We need to inspect the area where you've been conducting drilling operations. Illegal dumping. I haven't dumped anything illegal. Patricia got out of her car, her expression triumphant. The drilling operation has been disposing of toxic waste materials on the property without proper permits. I took photos over the weekend and filed a report with the County Environmental Compliance Office. I felt anger flash through me. That's completely false. Lone Star Mineral Extraction is a licensed operator. They follow all environmental regulations. Any drilling mud or cuttings are being handled according to Texas Commission on Environmental Quality Standards. Deputy Ramirez looked uncomfortable. Sir, we still need to inspect. If everything's in compliance, you have nothing to worry about. I called Dutch and explained the situation. He came over immediately, bringing all the company's permits and environmental compliance documentation. For the next hour, the deputies inspected the drilling site, while Dutch patiently explained each aspect of the operation and showed them the proper disposal methods being used. Finally, Deputy Ramirez shook his head. Everything appears to be in order here. All the permits check out, and I don't see any evidence of improper disposal. Patricia's face turned red. But the photos I took showed chemical containers and contaminated materials. Madam, those are standard drilling materials, all properly stored and labeled. There's no violation here. After the deputies left, Patricia remained by her car, staring at me with barely contained fury. I walked over to the gate. This needs to stop, Patricia. The HOA's attorney already confirmed you have no authority over mineral extraction. Filing false environmental complaints isn't going to change that. It's just harassment. This isn't over, she said quietly, but with such intensity that it sent a chill down my spine. You think you can just ignore community standards and do whatever you want. You're going to regret this. She drove away, leaving me standing there with a knot of worry in my gut. I called Marcus and told him what had happened. She filed a false report with the sheriff, Marcus said, his tone serious. Kevin, that could potentially be a criminal matter. Filing a false police report is illegal. At minimum, it's harassment. I think we need to consider seeking a personal restraining order against Patricia, separate from the HOA. Will that just escalate things further? She's already escalating. You need to protect yourself. Let me draft the petition. In the meantime, I want you to install security cameras covering your property entrance and the drilling site. Document everything. I spent the next 2 days setting up a comprehensive security camera system. 4 cameras covered different angles of my property, all feeding to a digital recorder that stored footage for 30 days. It felt paranoid, but Marcus was right. I needed documentation. The following Thursday, I had to drive into Midland for supplies. I was gone for about 3 hours. When I returned, I found chaos. My gate had been padlocked with a heavy chain and lock that wasn't mine. A large sign hung from the gate reading, "Property condemned by Sagebrush Estates, HOA no entry." Dutch and 2 of his crew members were standing outside the gate looking frustrated. Someone came by about an hour ago, Dutch said. Put up that chain and lock, posted the sign. My guys couldn't get in to service the well. I felt rage building in my chest. I pulled out my phone and called the non-emergency sheriff's number, then called Marcus. While I waited for the deputy to arrive, I reviewed my security camera footage on my phone. The video showed Patricia Whitmore's Lexus pulling up to my gate at 11:47 a.m. Patricia got out along with Dale Hoffman, the usually quiet HOA board member. Together, they wrapped the heavy chain around the gate and secured it with a padlock. Dale held up the condemned sign while Patricia wired it to the gate. They worked quickly, finishing in less than 5 minutes before driving away. Deputy Ramirez arrived about 20 minutes later, the same officer who'd responded to the false environmental complaint. I showed him the footage. That's clear evidence of criminal trespass and property damage, he said. They had no authority to lock your gate or post that sign. I'm going to need you to file a formal complaint. I want to press charges, I said. This is harassment and it's interfering with my business operations. The deputy called for bolt cutters, and within minutes my gate was freed. He took the chain, lock, and sign as evidence, and I provided him with copies of the security footage. Marcus called me back while the deputy was still there. This is serious, Kevin. They've crossed the line from civil HOA overreach into criminal behavior. Locking your gate could be charged as criminal trespass, unlawful restraint of trade, and possibly other offenses depending on how the DA wants to proceed. Over the next few days, things moved quickly. The district attorney's office opened an investigation. Deputies interviewed Patricia Whitmore and Dale Hoffman separately. I learned later that Dale immediately admitted to his involvement and claimed Patricia had convinced him it was a legitimate HOA enforcement action. Patricia, on the other hand, insisted they had authority under the covenants to secure properties in violation of community standards. The following Tuesday, I received a call from an assistant district attorney named Sarah Zimmerman. "Mr. Kimball, I wanted to update you on the investigation. We've decided to file criminal charges against Patricia Whitmore for criminal trespass and filing a false police report related to the environmental complaint. Dale Hoffman has agreed to cooperate in exchange for reduced charges. He'll be charged with criminal trespass as a Class B misdemeanor, but we're recommending probation given his cooperation and lack of prior record." What about Patricia? Given the pattern of harassment and the false police report, we're treating this more seriously. Criminal trespass is a Class A misdemeanor and filing a false report. If convicted, she could face jail time, though more likely she'll get probation and fines on a first offense. The news spread through Sagebrush Estates like wildfire. Within days, an emergency HOA board meeting was called. Robert Jennings, as treasurer, took over as acting president. The board voted unanimously to remove Patricia from her position and terminate her involvement in any HOA matters pending the outcome of the criminal case. I attended that meeting, sitting quietly in the back. Robert addressed the residents with obvious discomfort. "I want to apologize to Kevin Kimball on behalf of the board. Patricia's actions were not authorized by the rest of us and do not reflect the values of this community. We're implementing new policies to prevent this kind of overreach in the future, including requiring board decisions to be unanimous for any enforcement actions and consulting with an attorney before issuing any fines or penalties." After the meeting, Robert approached me. "Kevin, I'm sorry. I should have pushed back harder from the beginning. I knew Patricia was going too far, but I didn't want the conflict." "I appreciate that, Robert. I just want to move forward. The drilling operation is going well, and I'd like to be a good neighbor and part of this community." "You've been more patient than most people would have been. For what it's worth, several residents have approached me about exploring mineral rights on their properties. Your success has opened a lot of eyes to the potential value beneath our land." The criminal case against Patricia Whitmore proceeded through the system over the next several months. Marcus represented me in a parallel civil lawsuit against both Patricia personally and the HOA for the harassment and interference with my mineral rights operations. The HOA's insurance carrier settled quickly, paying damages and legal fees without admitting liability. Patricia's personal assets, however, were another matter. Her attorney tried to negotiate a settlement, but Marcus was firm. "Your client engaged in a sustained campaign of harassment, filed false police reports, and criminally trespassed on my client's property. We're seeking full damages for lost business opportunities, emotional distress, and attorney's fees." In the end, Patricia pleaded guilty to the criminal charges in exchange for 18 months of probation, community service, and substantial fines. The civil case settled for $60,000, which Patricia had to pay from personal funds after her homeowner's insurance denied coverage for intentional criminal acts. I felt no satisfaction in her downfall, only relief that it was over. The drilling operation on my property proved even more successful than initial projections. By the end of the first year, royalty payments were exceeding $15,000 monthly, transforming my financial situation. I paid off my mortgage, set up college funds for my nephews, and started planning to expand the ranch. True to Robert's prediction, several other Sagebrush Estates residents explored their mineral rights. Frank Henderson's property turned out to have even richer deposits than mine, and he leased to Lone Star as well. The initial fears about property values proved unfounded. If anything, the discovery of mineral wealth made Sagebrush Estates properties more valuable. About 6 months after Patricia's conviction, I was working on my porch when a car I didn't recognize pulled up. A woman in her 50s got out, looking uncertain. "Kevin Kimball?" she called out. "Yes?" "I'm Susan Whitmore, Patricia's sister. I wanted to talk to you if you have a few minutes. I felt my defenses rise, but something in her expression made me walk down to the gate. What can I do for you? I wanted to apologize for my sister's behavior. She's struggled with control issues her whole life. Being HOA president gave her an outlet for that, but she took it way too far. She's in therapy now, dealing with a lot of things. I'm not making excuses for what she did, but I wanted you to know she's getting help. I appreciate you telling me. I never wanted things to go as far as they did. I know, I've talked to several people in the community who said you were remarkably patient. Patricia created this situation entirely on her own. She's lost a lot because of it, her position, her reputation, most of her savings to pay the settlement. But maybe she needed to hit bottom to finally face her issues. After Susan left, I stood at the gate for a long time, watching the sun set over the drilling rig. The rhythmic pumping of the well had become a comforting background sound, a reminder of how much had changed in such a short time. I thought about Patricia, about how her need to control others had ultimately destroyed her authority and standing. I thought about how close I'd come to giving up, to just shutting down the drilling to avoid the conflict. And I thought about Marcus's words that first day. That's not how this works. He'd been right, not just about the law, but about standing up for what was rightfully mine. The mineral rights beneath my land were mine to develop, and no HOA covenant or overzealous president could change that fundamental fact. A year later, Sagebrush Estates had settled into a new normal. A quieter, less confrontational HOA board focused on actual community issues like road maintenance and common area upkeep rather than trying to micromanage residents' private property decisions. Robert Jennings proved to be a fair and reasonable president, and he was re-elected unanimously. I'd become something of an informal resource for neighbors exploring their own mineral rights. I connected several residents with Marcus and with Lone Star, and soon there were 4 active wells in Sagebrush Estates, all operating smoothly with minimal disruption to the community. The drilling on my property transitioned from the intensive initial phase to steady production. Dutch's crew still came by weekly for maintenance, but the dramatic equipment and noise were gone. Someone driving past my property might notice the wellhead and small pump, but otherwise, the land looked much as it had before. I used some of the royalty income to improve the property. I built a new barn, upgraded my fencing, and added a small guest house where my parents could stay when they visited from their ranch near Amarillo. Dad, who'd spent 50 years working marginal cattle land, would shake his head in amazement every time he visited. All that wealth just sitting under the ground all those years, he'd say, makes you think about all the ranchers who struggled when the answer was right beneath their boots. I also established a scholarship fund at Midland High School for students pursuing careers in geology, engineering, or mineral resource management. It felt important to give back, to help the next generation understand and responsibly develop the resources beneath Texas soil. One evening in late spring, about 18 months after the whole ordeal began, I hosted a community barbecue at my property. It was Robert's idea, a way to bring neighbors together and show that Sagebrush Estates was moving forward from the division and conflict of the Patricia era. More than 60 people showed up. I gave tours of the well operation to anyone interested, explaining how the drilling worked and the safety measures in place. Kids ran around the property while adults chatted and ate barbecue. Frank Henderson brought his guitar and led an impromptu sing-along as the sun set. At one point, Robert pulled me aside. You know, this whole situation could have torn our community apart, but you handled it with class. You stood up for your rights without being vindictive. You educated people instead of just fighting. That matters. I just wanted to develop my property, I said. Patricia was the one who made it complicated. True, but you could have responded differently. You could have been angry and divisive. Instead, you stayed focused on what was legal and right. That's leadership, Kevin. We could use more of that. A few weeks later, I was surprised to receive a letter in the mail with no return address. Inside was a single handwritten page from Patricia Whitmore. Kevin, it began. You don't owe me anything, not even reading this letter. But my therapist suggested I write to you as part of my recovery process. I spent 7 years as HOA president thinking I was protecting the community, But really, I was feeding my need to control things and people. When you started drilling, it triggered all my worst impulses. Instead of accepting that I was wrong legally, I doubled down, convinced myself I was right, and ultimately broke the law. I've lost nearly everything because of my actions. But worse than that, I hurt you and damaged our community. I don't expect forgiveness, but I want you to know I'm truly sorry for what I put you through. You deserved better, and I'm working to become a better person so I never hurt anyone like that again. Patricia. I read the letter twice, then filed it away. I didn't respond, not because I couldn't forgive her, but because I sensed she needed to complete her journey without validation from me. Her therapy, her recovery, her path to becoming better, those were hers to walk. The drilling operation continued to exceed expectations. By the second year, geological surveys suggested the deposits extended deeper than originally mapped, potentially adding years to the productive life of the well. Lone Star offered to renegotiate my lease with better terms, recognizing the exceptional quality of the find. Marcus and I became friends beyond our attorney-client relationship. He'd occasionally drive out from Midland for dinner, and we'd sit on my porch talking about property law, Texas history, and the changing landscape of mineral rights in residential areas. "You know you set a precedent here," Marcus said during one visit. "The way this case played out, the documentation, the clear establishment of mineral rights superseding HOA covenants, it's going to be cited in future cases. Other property owners facing similar HOA overreach now have a roadmap." Is that a good thing? Absolutely. HOAs serve a purpose when they stick to their legitimate authority, but too often they overreach, claiming powers they don't legally have. Cases like yours help define the boundaries, protect property rights while still allowing reasonable covenant enforcement. That's how the system is supposed to work. 3 years after that first confrontation with Patricia at my gate, I stood in almost the same spot, but the circumstances couldn't have been more different. Dutch had just left after a routine maintenance check, reporting that the well was performing beautifully with no decline in production. My bank account showed a balance I'd never dreamed possible before mineral extraction began. And most importantly, I was at peace with my place in the Sagebrush Estates community. I'd learned that standing up for your rights doesn't mean you have to be aggressive or confrontational. It means knowing what's legally and morally correct, having expert guidance, and staying calm in the face of pressure. Marcus's expertise had been crucial, but equally important was my willingness to document everything, follow proper procedures, and resist the temptation to escalate conflicts. The pumping well behind me represented more than just financial success. It symbolized the victory of property rights over bureaucratic overreach, of informed persistence over intimidation, and of community healing over division. My phone buzzed with a text from Frank Henderson. "Just got the quarterly royalty statement. This is insane. Drinks tonight at Red Steakhouse to celebrate?" I smiled and texted back my agreement. Frank had become one of my closest friends through this whole experience. We'd formed what we jokingly called the Sagebrush Mineral Rights Club, though it was really just the two of us and occasionally a few other residents comparing notes and sharing updates on our wells. As I walked back to my house, I thought about how different my life might have been if I'd given in to Patricia's initial demands. If I'd shut down the drilling operation to avoid conflict, I'd have lost hundreds of thousands of dollars in royalties. More than that, I'd have surrendered my legal rights because of illegal HOA overreach. Instead, I'd stood firm, educated myself on the law, hired expert representation, and seen it through to a successful conclusion. Patricia had faced consequences for her criminal behavior, but she was also getting help and hopefully becoming a better person. The HOA had learned important lessons about the limits of their authority, and the community had emerged stronger and more prosperous. That evening at Red Steakhouse, Frank and I raised our glasses in a toast. "To mineral rights," Frank said with a grin. "To knowing how it works," I replied, echoing Marcus's words from that first phone call years ago. We clinked glasses and drank, surrounded by friends and neighbors who'd all learned the same lesson, that property rights in Texas are serious business, that mineral extraction follows its own rules, and that no HOA covenant can override state law. The story could have ended in bitterness and ongoing conflict. Instead, it ended in prosperity, community growth, and hard-won wisdom. Patricia's attempt to ban drilling on my land had failed, not because I was more powerful or more stubborn, but because Marcus was absolutely right from the beginning. That's not how this works. And thank God for that.